This proceeding will start in 1 minute. This impeachment proceeding is now called to order. So may I request the ComSec to call the roll of members.
Thank you, Your Honor. Roll call of members of the Committee on Justice. The Honorable Chairman Reynaldo Umali. The Honorable Vice Chairpersons Vicente Veloso, Doy Leachon, Henry Wominal, Arnulfo Fuentebella, Strike Revilla. The regular members, Honorable Representatives Roy Loyola, Marlene Primicias Agabas, Jerry Treñas, Lucy Gomez, Rosemary Baby Arenas, Bayani Fernando, Ruel Peter Gonzaga, Ramon Rocamora, Federico Ricky Sandoval II, Horacio Swansing Jr., Jericho Jonas Nograles, Lawrence Lemuel Fortun, Munir Arbison, Arthur Yap, Divina Grace Yu, Noel Villanueva, Manuel Luis Lopez, Edward Vera Maceda, Jose Christopher Belmonte, Kakabag Au, Josephine Ramirez Sato, Xavier Jesus Romualdo, Juliet Marie Ferrer, Edwin Ong, Ann Hofer, Rodel Batocabe, Ron Salo, Sherwin Tugna, Carlos Roman Uybareta, Carlos Isagani Zarate, Salvador Belaro Jr., Antonio Florendo, Mahmoud Mending Jr., Emeline Aglipay Villar, Michael Romero, Luisa Loren Cuesma, Rodante Marcoleta, Robert Ace Barbers, Ferginel Biron, Rodolfo Albano III, Romeo Acop, Gloria Macapagal Arroyo, Abigail Faye Ferriol Pascual, Harley Neil Abayon III, Manuel Monsur del Rosario III. The Honorable Ex-Officio Members, the Honorable Speaker Pantaleon Alvarez, the Honorable Deputy Speakers Reneo Rani Abu, Eric Singson, Fredenil Castro, Romero Kimbo, Mercedes Alvarez, Gwendolyn Garcia, Maylene Garcia Albano, Pia Cayetano, Sharon Garin, Linabel Ruth Villarica, Bai Sandra Sema, Ferdinand Hernandez, Frederick Eric Abueg, Rolando Andaya Jr., the Honorable Majority Leader Rodolfo Fariñas, the Honorable Senior Deputy Majority Leader Juan Pablo Bondoc, the Honorable Deputy Majority Leaders Arthur Defensor Jr., Roger Mercado, Ann Hofer, Vincent Crisologo, Aurelio Don Gonzales, Victoria Isabel Noel, Gerald Anthony Gullias Jr., Arnel T., the Honorable Minority Leader Danilo Suarez, the Honorable Senior Deputy Minority Leader Jose Atienza Jr., the Honorable Assistant Minority Leader Harlene Neil Abayon, the Honorable Deputy Minority Leaders Alfredo Garbin Jr., Eugene Michael De Vera, Anthony Bravo, Harry Roque, Luis Jose Angel Campos Jr., and the Honorable Chairperson of the Committee on Accounts, Elenita Milagros Ermita Buhain. Your Honor, the roll call shows that there are 20 regular and ex-officio members who responded to the call.
Okay, so there being a quorum, what is the pleasure of Congressman Wominal?
Mr. Chair, I move to dispense the reading of the minutes of the previous committee hearing.
What about the approval?
I will file a separate motion after the approval of the dispensal of the reading, Mr. Chair.
There is a motion duly seconded. There being no objection, the reading of the minutes of the September 13, 2017 meeting is hereby dispensed with.
In connection to that, Mr. Chair, I move for the approval of the minutes of the previous committee hearing.
Mr. Chair,
Congresswoman Gwen.
if I may, I would support the motion or second it even, for as long as there would be some amendments to the minutes that are, that seem to reflect what went on in the last committee hearing. And I would want to refer to page 2,
Page 2.
where a number of ex officio members and guest members were identified as endorsers of the complaint. This representation would like to manifest that I too was an endorser of the impeachment complaints that we had taken up. It would seem that if any of the members here listed would be identified as endorsers, then we might as well identify all of those that had actually endorsed the two complaints in the, which
Page 2.
sought to impeach Chief Justice Sereno.
The proposed amendment being in order, let the I hereby direct the COMSEC to incorporate all the names of the endorsers who were present in the last hearing.
Thank you, Mr. Chair.
Do I hear a second to the motion?
Second.
There being no objection, the minutes of the September 13, 2017 meeting is hereby approved.
As amended.
As amended. So, this is the initial deliberation on the verified complaint against Comelec Chairman Andy Bautista, filed by former Representative Jacinto Paras and Attorney Ferdinand Tapatio, and endorsed by Representative Gwen Garcia, Representative Abraham Tolentino, and Representative Harry Roque. So, good morning, ladies and gentlemen, my distinguished colleagues, both regular and ex officio, and other members present. Just last week, this committee was in a similar situation when we heard the impeachment complaints against Chief Justice Lourdes Sereno. Today, we are once again mandated by the Constitution as representatives of the people to conduct this impeachment proceeding against another high official of the government as part of the systems of checks and balances to determine the fitness of the Comelec chairman to continue performing the duties of his high office. In a span of 2 regular sessions under the 17th Congress, the Committee on Justice has now initiated 3 impeachment proceedings. The first being against President Rodrigo Roa Duterte, the second on Supreme Court Chief Justice Sereno, and now the instant case. For today, we will hear the impeachment complaint filed by former Congressman Jing Paras and Attorney Ferdy Topacio, as mentioned, endorsed by 3 of the illustrious members of this chamber, and these are Congresswoman Garcia, Congressman Tolentino, and Roque. And this is filed against, as I said, the Comelec chairman. For the record, the impeachment proceeding versus President Duterte was deemed sufficient in form. The committee opted to be liberal in finding the complaint sufficient in form, notwithstanding the defect in the verification thereof, with a fair warning to all that this will be the last time the committee exercises liberality in finding a defective complaint sufficient in form. However, the committee opted to declare the same complaint insufficient in substance since the complainant, Congressman Gary Alejandro, admitted not having any personal knowledge of his allegations. Neither were the allegations culled from authentic records, as in fact, no authentic records were appended to the complaint. Thus, the committee deemed all of the allegations therein as hearsay. On the other hand, of the two complaints versus Chief Justice Sereno, only the complaint filed by Attorney Gadon was found sufficient in form and substance, since the allegations therein, while not of Attorney Gadon's personal knowledge, were culled from authentic documents that were appended to the complaint itself. The second complaint, filed by Mr. Dante Jimenez and Attorney Eligio Marliari, was dismissed due to a defective verification, which I would like to read into the records. Today, and I quote, nasa yung verification? Kay Malyari. Let me just quote the verification of Dante Jimenez and Attorney Malyari, and I quote, that we are the complainants in the above entitled verified complaint for impeachment, that we have caused the said complaint to be prepared and have read the contents thereof, and that the allegations therein are true of our own knowledge and belief on the basis of our reading and appreciation of documents and other records pertinent thereto. Signed, Dante Jimenez and Attorney Malyari. And so, as mentioned, this verification was found to be defective, which was the basis for the dismissal of said second complaint against Chief Justice Sereno. Today, this committee is confronted with a similar situation where the verification of the complainants in the instant complaint appears exactly the same as that in the second impeachment complaint against Chief Justice Sereno. And this was filed by meanwhile, a revised verification, same verification. A motion has now been filed to substitute the verification filed before this committee, together with the attached substitute verification, now containing the provisions or the allegations as required under our rules, and this we will tackle before we subject this impeachment complaint to a vote later on sufficiency in form. This complaint having been filed on 23 August 2017 and endorsed by Representatives Garcia, Tapatio, and Roque through an even-dated resolution of endorsement and referred to the Committee on Justice on September 7, 2017, the Chair hereby declares that this impeachment proceeding has been initiated, and accordingly, the one-year bar rule on impeachment cases against Comelec Chairman Bautista has taken effect last September 7, 2017. Otherwise stated, no impeachment complaint against him may be filed 1 year therefrom. At this juncture, let me just reiterate some important guideposts in an impeachment proceeding. In particular, the rules that would govern our proceedings are the rules of procedure in impeachment proceedings of the House of Representatives in the 17th Congress as amended, adopted by the House on August 23, 2016, and published on August 26, 2016 in the Manila Bulletin and Philippine Star, with a caveat that as articulated by our Majority Leader Rudy Fariñas, this will be the last time the committee exercises liberality in finding defective complaints sufficient in form. And this is contained in our committee report number 257 submitted by this committee on May 22, 2017 and adopted by the plenary on May 30, 2017. The rules governing the proceeding dictates as also held in a long line of cases that upon due referral, the committee shall determine whether the complaint is sufficient in form and substance. As we go forward today in the proceedings, I enjoin the voting members of the committee to be guided by the precedents set by the committee in the two previous impeachment proceedings on the determination of sufficiency in form and substance. Of course, in determining sufficiency in form, the requirements as provided in the Constitution are for complainants filed by any member of the House, the complaint must be verified. For verified complainants filed by any citizen, the complaints must be verified and endorsed through a resolution of endorsement by any member of the House of Representatives. Obviously, this complaint falls under the second category. If the committee finds the impeachment complaint sufficient in form, we will then proceed to determine sufficiency in substance of the complaint. Section 4 of the Rules of Procedure in Impeachment Proceeding states that the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of this committee. As we have followed and practiced in previous proceedings, the voting members of the Committee on Justice always conform to the individual appreciation of each representative in determining whether a verified impeachment complaint is sufficient in substance. The member will be given the opportunity to be heard prior to the voting on the sufficiency of substance of the verified impeachment complaint. The same is true with respect to the voting on sufficiency in form. After the committee's deliberation and determination of both sufficiency in form and substance, it will then proceed to determine whether the grounds as alleged in the complaint constitute an impeachable offense. As provided in Section 6 and 7 of the Rules on Impeachment, the committee will proceed by requiring the submission of an answer under oath, affidavits by respondent and counter-affidavits, evidence and other memoranda before this committee. In the event this committee finds the grounds alleged in the complaint are sufficient based on an impeachable offense, the committee shall thereafter determine whether probable cause exists on the basis of evidence submitted to the committee. Again, the determination of sufficiency of the grounds and existence of probable cause for impeachment shall be based on the individual discretion of the members. Whatever the conclusion of this committee would be, and the decision of this committee that will be arrived at, whether it will be for a dismissal of the complaint or that the complaint is found sufficient, the committee shall file a committee report which includes a corresponding resolution setting forth the articles of impeachment or its resolution dismissing the complaint. The House in plenary session will then vote whether or not to approve the resolution endorsing the articles of impeachment, to approve the resolution dismissing the complaint, or to override a resolution dismissing the complaint by 1/3 vote of all House members. In closing, let us remember that we are here as part of our constitutional mandate to safeguard accountability in government, and to ensure that the high officials of the land are fit to perform their mandate and functions. We are constitutionally bound as elected representatives of the people to protect the sanctity of government service. We must also remember that the impeachment process, while it is political in nature, is a democratic one. It is exercised by individual members based on their individual appreciation of circumstances and facts. We must never falter in our mandate to safeguard and protect the Constitution, most especially the people from abuses of high officials. Thank you, and a pleasant morning to all. So, as I mentioned, there is a motion to admit a substitute verification together with a substitute verification. Any motion to introduce this pleading pending before that we need to first dispense with before we proceed on the deliberation on the sufficiency in form of this impeachment complaint?
Mr. Chair, I move
Please. Yeah.
that we grant the motion to substitute the proper verification as duly attached, and I do so on the following grounds. Number one, the substitution is not prohibited. There is nothing explicitly provided in the rules which provides that any matter of form cannot be corrected. In fact, our rules explicitly provides under Section 4, this is the rules on impeachment proceedings, that if a complaint is found insufficient in form, it shall be returned to the SecGen with 3 session days and with a written explanation of insufficiency. The Secretary General shall return the same to the complainants together with the committee's written explanation within 3 session days from receipt of the committee resolution finding the complaint insufficient in form. Now, the next paragraph, the first sentence says, should the committee find the complaint sufficient in form, it shall then determine if the complaint is sufficient in substance. The same paragraph says that if the committee finds that the complaint is not sufficient in substance, it shall dismiss the complaint and shall submit its report. Accordingly, Mr. Chair, our rules provide that insufficiency of form may be corrected and rectified, and that it is in fact a determination that a complaint is insufficient in both form and substance that results in the dismissal of an impeachment complaint. Now, this construction appears to be consistent with the jurisprudence laid down by our court that mere matters of form may be rectified because technicalities should not be made to trump substantial justice. Now, as you know, I'm one of the endorsers of the complaint, and I did endorse it because I felt that the matters alleged in the complaint involve matters of transcendental importance. It involves the issue of integrity and probity of no less than the chairman of the Commission on Election, which inevitably will affect the integrity of all electoral exercise, which is the most important exercise in any democracy. What are the jurisprudence that I mentioned, no? Which recognizes that matter of forms can be corrected? There's a multitude of cases, but let me quote from some. Zalda versus Zalda. The court said, the court may in fact order the correction of the pleading if verification is lacking, or it may act on the pleading although it may not have been verified, where it is made evident that strict compliance with the rules may be dispensed with so that the ends of justice may be served. Pagadora versus Ilaw. And I quote, it is well settled that the liberal construction of the rules may be invoked in situations where there may be excusable formal deficiency or error in a pleading. Besides, fundamental is the precept that rules of procedure are meant not to thwart, but to facilitate the attainment of justice. Now, we will not argue at this point on the issue of verification as contained originally, no? But we are arguing now that because the matter of this complaint has been referred by plenary to the committee, it is within now the jurisdiction of this committee to determine whether or not to admit the substitute verification as filed by the complainants. My question now is, since it is not prohibited, since the rules contemplate even that formal defects may be rectified, why should we not allow now the substitution as played by complainants, if only because we need to get to the truth of the allegations as it affects all of us having participated in an electoral exercise, all of us conceivably also in the future, in the immediate future, will still participate in this electoral exercise, underscoring the fact that it is not a domestic squabble that concerns us in this Congress. It is the very integrity of our democracy at stake. And therefore, for all these reasons, Mr. Chair, I move that we admit the substitute verification as submitted by the complainants.
Mr. Chairman.
Thank you,
Mr. Chairman.
Objection, Mr. Chairman.
Mr. Chairman.
Okay, what is the objection of the...
Mr. Chair, the motion is not yet seconded.
I have seconded.
Objection to the motion, Mr. Chairman.
So,
Objection
let
to the
us hear
motion, Mr.
first
Chairman.
the objections to the motion.
Mr. Chairman.
I also register my objections so that I can be given the time to explain my objections.
This representation also, Mr. Chair,
Objection
is also registering
Please
its
list
objection.
down the objectors. Go ahead, Congressman.
Mr. Chairman, dear colleagues, as the chairman so mentioned earlier, this is the fifth impeachment we have heard so far,
Third, this Congress. This is the third this Congress.
including the Alejandro complaint, the fourth. Fourth, yeah. So, Mr. Chairman, to be true to our previous decisions in the mentioned three previous impeachment complaints, I note the statement of the Honorable Roque, where errors may be corrected, and indeed there is a precedent for that. I bring to the attention of this committee now the impeachment complaint filed against President Noynoy Aquino by Renato Reyes Jr. and the discussion there, which was captured in Committee Report number 450 on House Resolution 1543, submitted by the Committee on Justice, October 2, 2014. There was an error, likewise, in that impeachment complaint. And may I read from the committee report? Members of the committee debated on the sufficiency in form of the Reyes complaint when Representative Rodolfo Fariñas pointed out that the resolutions of endorsement by Representatives Colmenares, Zarate, Hiccup, and Ilagan all read, "Now therefore I hereby resolve to endorse as I hereby endorse the attached verified complaint by Bagong Alyansa Makabayan et al., represented by its Secretary General Renato M. Reyes, and other complainants, and strongly recommend that the same be given due course by the House of Representatives." End quote. Some members, this is the committee report, viewed that the resolutions and consequently the complaint itself were defective since the complaint was filed by Renato M. Reyes Jr., among others, in his personal capacity and not as a representative of Bayan, open parenthesis, in which case a board resolution authorizing Mr. Reyes to represent Bayan as complainant is needed, close parenthesis, as admitted by Mr. Reyes during the meeting. On the other hand, some members of the committee submitted that a simple amendment to the resolutions would suffice in the interest of justice and liberality. The amendment of the after a debate, a motion was made to allow, in the interest of justice and liberality, the amendment of the resolutions of endorsement. With 51 votes in favor, 1 against, and with 4 abstentions, the motion was carried. Thus, the last clause of the resolutions of endorsement by Representatives Colmenares, Zarate, Hiccup, and Ilagan were amended. and the committee report goes on. So, dear colleagues, Mr. Chairman, it can be gleaned from this committee report that the voting was carried in favor of an amendment to the error because of liberality. And it has already been stated by our majority leader in the Alejandro complaint, this would be the last time the Committee on Justice would allow for errors in liberality in form. To be true to the Honorable Alejandro, to be true to the other endorsement complaint which we did not pass according to form, we must apply the same standards to this before us. Liberality has been ruled out, and therefore I must object to the motion of the Honorable Roque. Thank you, Mr. Chairman.
Thank you for that. We now recognize Deputy Speaker Fred Castro for
Mr.
his
Chairman.
objection.
Honorable Roque has cited several cases in order to underscore his argument that there is no prohibition in the amendment of any complaint insofar as form is concerned. This representation takes exception to the representation of Honorable Harry Roque, because in the Gary Alejandro impeachment against the President Rodrigo Duterte, the committee has made it clear in no uncertain terms that admission of a complaint, notwithstanding defect in the verification, in the exercise of liberality, would be the last time. And therefore that caveat or that warning by the committee that for the last time it will entertain impeachment complaint notwithstanding that it is defective in form is itself a clear prohibition that the next time around the committee will no longer entertain any defective impeachment complaint in form. Second, the cases cited by the Honorable Harry Roque refers to cases decided by our courts, by the Supreme Court. But contrary to the decision of the Supreme Court, the rules of court or decision of the Supreme Court could only have suppletory character insofar as impeachment proceeding in these halls of Congress is concerned. Reason, we have our own rulings, in which case decisions of the Supreme Court cannot take precedence over the rulings of the committee or the House of Representatives itself. No less than the case of Alejandro versus Rodrigo Duterte underscore this argument, because the ruling in the Alejandro versus President Duterte, which takes in the form of stare decisis in this House, has been approved in plenary, not only by the committee, but by the plenary. In effect, while we respect the jurisprudence of the Supreme Court, we respect that as applicable in our courts as primary authority, but only secondary authority insofar as impeachment proceedings decided by the plenary in these halls of Congress. Accordingly, Mr. Chairman, Mr. Majority Leader, this representation on the basis of the argument preferred moves for the dismissal of the complaint. Dismissal na yung akin eh.
Ano ba sa atin?
Hindi.
Tinira mo na yung mic na.
Wala eh.
Dismiss na eh.
Hindi lang refusal eh, kundi dismissal na eh.
Dismissal na eh. Hindi lang
Manong Fred,
Ayan.
with your indulgence, pwede bang, hindi mo naman kailangan ng mic, pwede ba patanggal na natin yan? Nadidelay yung proceedings eh.
Mr.
Okay,
Chairman,
so,
are we...
Okay,
Di ba?
sige, sige.
Na-record ba yung sinabi niya kanina? Pakiulit mo dahil hindi daw na-record.
Without mic, without mic. Anyway, this proceeding is now resumed.
May ask, were the statements of the gentleman recorded? Na-record niyo naman?
Please answer. Meron ba? Recorded, duly recorded?
Okay, thank you.
Okay. Sige, so we now recognize...
Mr. Chair.
we will not entertain the motion because there is a pending
Okay,
motion.
thank you. That was what I needed from the chair.
Yeah. So we now recognize Congressman Lagman.
Thank you, Mr. Chairman. I am objecting to the presentation and motion of the distinguished Representative Roque for the following reasons. Number one, the substitute verification has no legal basis in the rules of procedure for impeachment cases of the House. There is no specific rule granting any party the right to amend the verification or the complaint for that matter. It is flawed to take the position that just because the pleading or amendment is not allowed, is not prohibited, it must be allowed. Number two, since the paras Tapatio complaint has been referred to the Committee on Justice of the House, any determination with respect to form must be based on the original verification submitted by the complainants. Number three, the attempt to make a substitute verification is a clear admission that the original verification is fatally defective. Number four, the motion to admit substitute verification is not even filed with leave of the House Committee on Justice. In fact, it is addressed to the House of Representatives, and the House of Representatives in plenary has not acted on the substitute amendment. Since it is addressed to the House, then the House must take action on it, and if it wants, it could refer the substitute amendment to the Committee on Justice. It has not done. So legally and technically, the substitute verification is not with this committee. Next, Mr. Chairman, the amended verification was submitted alone it was not attached to any complaint. And the amendment of the verification is a virtual amendment of the complaint, which was not submitted by the complainants. Next, it is required, Mr. Chairman, that any amendment, there should be a submission of the amendment, including the complaint, and highlight the amendment thereto. Next, if we entertain this substitute verification, which is virtually an amendment to the complaint, we will be we will not be observing the one-year rule ban, because this committee has already jurisdiction with respect to the referral of the Tapatio Paras complaint, and the ban has already started. An amended complaint and an amended verification will violate that one-year ban. For all of these reasons, Mr. Chairman, I am objecting to the position and motion of the distinguished Roque.
Thank you, Congressman Lagman. We now hear the objection of Congressman Uaminal.
Good morning, Mr. Chair. This humble representation is objecting to the motion because of the following grounds. First, in the case of Alejandro versus the President, it is this humble representation that moved for the sufficiency in form, but it was faced with so many objections from the members of this House. I was arguing to set aside technicality in furtherance to substantial justice, which in the final round, after I asked for an executive session, my motion was carried with the clear amendment introduced by the Honorable Majority Leader, the Honorable Fariñas, that should be the last action of the committee to consider liberality. In the case of Jimenez against Chief Justice Sereno, when I read the verification to have also the same defect with that of the Alejandro case, I was the one who first raised the issue that in our previous decision, we had already agreed to set aside liberality and to set up this standard of procedure in the determination as to the sufficiency in form for the future impeachment proceedings. So that allowing the amendment of the verification is in effect allowing liberality, which will now run counter to the standard procedure that we had agreed. Secondly, it is my position that amending the verification is a substantial amendment because it will affect the substantial right of the respondent. And then, being a substantial amendment, therefore, will be in violation of the one-year bar rule, as cited in the case of Gutierrez. The one-year bar rule shall apply once the impeachment will be referred already to the Committee on Justice. And this case was referred to us on September 7, and the amendment was filed on September 13. While it is true that in the proposed amendment, it was addressed, it was in the heading of the House of Representatives, but it is not filed before the House of Representatives. That's why it is not taken by the plenary, because it is filed directly to this Committee on Justice, which is, it is my position that the motion is improperly filed before this committee. And with that, Mr. Chair and my distinguished colleagues, I am objecting on the allowing of the motion of the Honorable Roque to amend the verification.
Thank you, Vice Chair Omnal. We now recognize Congressman Salo for his objection.
Thank you very much, Mr. Chair. At the outset, I'm one with the complainants and the endorsers in seeking the truth, in knowing the truth, in digging the truth. I respectfully submit, however, that the search for the truth cannot be made at the expense of other equally important and fundamental values, principles, and policies that our society uphold and from which our democracy is anchored. This cannot be done and should not be done. I respectfully note that the motion on the proposed amendment of verification is creatively presented as it has the same effect, objective or effect, of ensuring that the complaint shall be admitted despite its obvious defect. By allowing it to be cured, preempts and changes the inevitable effect, the dismissal of the complaint. As such, the motion is inextricably linked with the discussion on the complaint's insufficiency in form. Mr. Chair, this is not a mere substance, form, or substantial technical dichotomy issue, or something of transcendental importance. This is an issue that goes to the very core or the foundations of our democracy. First, this is about laws and rules. We have just hosted the ASEAN Interparliamentary Assembly, and we wanted everyone to know that in this part of the world, we are governed by laws and rules and not the whims and caprices of men. That laws and rules are primordial even if these go against our personal desires, and our actions and decisions should be undertaken based on set rules. And while laws or rules may be changed, they cannot be changed at the middle of the game to accommodate certain complaints. Second is about fairness. We should use the same yardstick that we use in scrutinizing the impeachment complaint against the Chief Justice with the current complaint. We cannot treat the current complaint differently with the VACC complaint against the Chief Justice, which we have just dismissed, as there exists no substantial difference between the two. To do otherwise would be unfair and unjust, not just to the parties but to all our countrymen. And third, this is about consistency and predictability of results. As I oftentimes joke in my class, this is the paradox with the civil law countries such as the Philippines and common law countries such as England. In civil law countries, everything is written. And yet, even if these are already written, you don't usually get the same results, even in similar cases, as lawyers would always have a way of justifying your actions or failures. Yet, in common law countries, even with an unwritten constitution or law, you get consistent and predictable results. No wonder most common law countries are the preferred legal systems among private parties. But perhaps this is a usual challenge faced by young democracies, such as the Philippines. However, our legal system needs to grow and mature and to respect and apply laws and rules as they are written. Certainly, the verification form is not very difficult to follow or to comply with, Mr. Chair, particularly among lawyers who are presumably learned or trained in the practice of law. And the failure to comply with the required form should merit the expected consequence, the dismissal of the complaint for being insufficient form. Thank you very much, Mr. Chair.
Thank you, Congressman Salo. We now recognize Vice Chairman Doyle Leachon.
Good morning, Mr. Chair, and of course to our dear members, so with our visitors at the hearing on this Committee of Justice. Actually, Mr. Chair, going to this hall, to my mind, I have more or less concluded that this committee, so with the Filipino people, have been seeing a continuing phenomenon on how the Constitution would work. And really, the Constitution has been operative in this country and has been provided or has been providing a very clear concept of democracy. Why? Because for the past months that I have been your vice chair, I have seen the continuing phenomenon. Why? Because in the Constitution, there are more or less about 7 agencies or officers who are impeachable. But in about less than 6 months, this committee, more or less out of liberality, has accommodated more or less about 3 impeachment cases. One against the president, which we dismissed. The second was against the Chief Justice. The first complaint was accommodated. The second one was dismissed. And now, another constitutional body is being questioned and is being threatened to be removed from office, of course, on various grounds. Now, going to the meat of the issue, the Congress, under the Constitution, definitely has to play its role as a defender, and it's operating as a politico-legal mechanism, because Congress, by virtue of impeachment, is definitely tasked primarily as the protector of the people, as a body politic. Of course, we have our good friends here, our illustrious members of the Congress, and of course, reading the grounds. But in answer to the motion of our good friend, Congressman Harry Roque, that the motion to admit the supplemental verification be admitted, I have these 2 cents worth to say. Number one, not actually just very recent, about a week ago, we decided the case of the impeachment case against Chief Justice Sereno. And the second case was dismissed, which was filed by Dante Jimenez of the VACC. And it's very clear. When I read yesterday and when I asked for the copy of the impeachment complaint against Chairman Bautista, undoubtedly, it's a perfect, wholly excellent copy of the verification of the Sereno case, which we dismissed. In fact, we dismissed it with prejudice. Going to the meat of the issue right now, as again, I would like to say that if we will deviate from the previous ruling, definitely this Congress will be criticized not only by the members but by the people. The whole Filipino nation is looking at us. We had our decision a week ago, and to deviate from the previous ruling is actually out of order, Mr. Chair. Finally, it was said that the admission should be admitted out of liberality, because in various Supreme Court cases, the Supreme Court has held that it should be, as a matter of procedure, be dispensed with in lieu of the substantive requirement. But then, Mr. Chair, I have 2 grounds. Number one, the issue of impeachment is provided for very clearly to be under the exclusive jurisdiction of the House or of Congress as an institution. Therefore, all procedures should be within the realm and jurisdiction, power, and authority of the House of Congress, and not before any courts of justice, unless the acts or actuations of Congress would be ultra vires. Considering, therefore, Mr. Chair, considering the premises, because of consistency and, of course, to conform with the uniform procedure that this committee has implemented, and for future purposes, so that a similar complaints or similarly situated may not be entertained, with due respect to Congressman Roque and our good friends endorsers, I would like to vote for the objection to the motion. Thank you, Mr. Chair.
Congressman Leachon, we now recognize Congressman Fortun, and after that, Congressman Gonzaga and the majority leader.
Thank you, Mr. Chairman. Just very briefly, Mr. Chairman, let me just emphasize, Mr. Chairman, that the verification is not an ordinary formal requirement. It is an indispensable requirement in impeachment complaints, the absence of which kills the complaint itself. Because while we call it a formal requirement, Mr. Chairman, I would like to posit the view that it is not a mere formal requirement, because the verification goes into the very substance of the complaint itself. Because the verification contains the attestation and confirmation by the complainant himself, or themselves for that matter, of the existence of documents, of the existence of authentic documents, and of the truthfulness of the allegations therein, according to his or their personal knowledge, Mr. Chairman. That is why the Supreme Court, in many cases, has consistently decided that an unverified complaint or a complaint that has defective verification is treated as an unsigned pleading. And an unsigned pleading has no legal effect whatsoever, Mr. Chairman. So on that basis, Mr. Chairman, especially so that this is not an ordinary complaint before regular courts, but a complaint against officials of a democratic institution, I suppose, Mr. Chairman, and I think that with due respect to the Honorable Harry Roque, his motion must fail, Mr. Chairman.
Thank you, Kong Fortun. Kong Gonzaga, you now have the floor.
Thank you, Mr. Chair. While is it true that the rules on impeachment does not contain provision as to the regard to the amendment or the acceptance of the amendment of any defect in the complaint, it is also true that when the majority floor leader introduced the sort of an amendment to the procedure when we decided the case of Alejandro versus President Duterte, somehow that liberality thing was a thing of the past. The decision of the committee in the Alejandro case and the introduction of the no more liberality in the next procedure, impeachment procedure, that is tantamount to an amendment of the rules of procedure. It becomes our jurisprudence. It becomes part of the rule in Congress. Because it is an amendment to the rules of procedure, therefore, it becomes, and we are bound to it. So, bumoto ako noon, bumoto tayong lahat, and with due respect to Harry Roque, he voted in favor of the introduction of non-liberality. Because we voted, we are then bound by it. So, nagiging part na yun sa rules of procedure natin. So, I think the move of Harry Roque must fail based on that ground.
Thank you. We now hear Majority Leader for his objection.
Thank you, Mr. Chairman. Being the last has handicaps because all the arguments have been already advanced. So I adapt all the arguments made by my colleagues, especially Deputy Speaker Castro and Manong Edsel, because I think they adopted mine also by mental telepathy. First of all, the Honorable Roque mentioned that it will be returned to the Ito po ang rule. If it is insufficient in form, it shall return the same to the Secretary General within 3 session days with a written explanation of the insufficiency. The Secretary General shall return the same to the complainants together with the committee's written explanation within 3 days from receipt of the committee's resolution finding the complaint insufficient in form. From dust to dust, from us to us. Ibabalik na, patay na eh. Because in the second paragraph, it already deals if the committee finds it sufficient in form. So, patay na, kaya babalik siya. What will you do with it? Change it? Then he will refer it to the speaker? Wala na, barred na eh. Because the proceedings have been initiated already. Pareho rin po yan. Kaya lang, we already stated during the Alejandro case na nga, dito na lang, i-dismiss na yan para clear na dismissal na yung nangyari. But that's the same. Like the gentleman said, it is tantamount or same as an unsigned pleading. Another thing po, this complaint as aptly cited by Representative Blagman was referred by plenary action. From when you filed the complaint, it was referred to the Speaker. The Speaker referred it to me as Chairman of the Committee on Rules. We reviewed it, included it in the calendar of business, and plenary referred it to the committee. Yun po yung verification. Now, the committee cannot change that because that is the act of plenary. Otherwise, the committee will be going against plenary action. Another thing, as aptly pointed out by Manong Edsel, the motion itself is, we should not have taken cognizance even of it because it is addressed to the House of Representatives. Ito po complainants by counsel unto this Honorable House of Representatives. It is not to the Committee on Justice. Kaya nga, sayang din yung argument natin dito. It was improperly filed because it is addressed. In fact, the heading itself is House of Representatives. There is no Committee on Justice. And even the prayer prays to the wherefore premise, it is respectfully prayed that the Honorable House of Representatives admit this is not we are the committee. Yung po very important po yung mga yun eh. And then if you look at this motion to admit, pati doon sa certification niya, medyo mali-mali naman po. Sabi dito, I certify that I have examined the affiants and I am satisfied that they understood the contents of their complaint. Eh, wala naman pong complaint dito eh. It is just a motion. So, even the certification by the notary public is defective because there is no complaint. This is just a motion to admit and a substitute verification. And then, nagiging infirm pa po ito because the original verification was made before the Secretary General, which is the proper official, so that we can ask him if he examined you. But this now, substitute verification was made by a notary public, not through the Secretary General. So, we cannot even ask Maridel Tambis, tama ba ito? The reason why it should be verified before the Secretary General because he is the House official tasked to do all of these things. Another thing po, the gentleman cited the rules of court. As a rules of court, like the other colleagues already, the honorable colleagues have already stated, supplementary lang, sabi ni Chief Justice, Deputy Speaker Castro. Supplementary po dahil, you know why? Under the rules of court, you have the right to amend your pleading before the other party answers. You can even change your pleading. Dito nga, if you apply the rules of court, pwede nyo palitan yung buong pleading nyo dahil hindi pa naman sumasagot si Chairman Bautista. In fact, under the rules of court, pwede mo pang i-amend yung pleading mo to conform to the evidence. Kasi nga, why? To avoid multiplicity of suits. That's why the court allows that para hindi na, sige, babalik mo, i-amend, if-file uli, edi doble trabaho. But not here. Because here, once that is dismissed, you have to wait 1 year before you can refile. So, stricter po ang rules dito properly because these are an elite group of public officers who have been placed in a pedestal high there so that they will not be disturbed in their constitutional functions. Hindi po pwedeng basta. That is why I stated before kay Congressman Alejandro, the Constitution itself requires that the complaint should be verified. Hindi po legal requirement to, constitutional requirement. And there is only one other instance in the Constitution where a verified complaint is required. That is for exclusion or inclusion of voters. Yan lamang po, mandato po ng Constitution yan. So, for those reasons, and this one, ang matindi pa po rito, baka magkaroon tayo ng perjury dito. Because in their first verification, based on knowledge and belief, and upon reading of documents, and then biglang papalitan lang, personal knowledge namin ito, at saka based on authentic records. But if you look at the records and the allegations, you will see that most of them are not their own personal knowledge. We will go into that. Nagugulat nga po ako eh. Several paragraphs are quotation from newspaper accounts. In paragraph 415 is a quotation from a GMA news story without a non-author. Tignan po nyo, paragraph 15. Paragraph 16, 17, 18, 19, 20, puro quote from one John Vic Mateo of the Philippine Star. So, for these reasons, Mr. Chairman, I support the objection to the motion and also pursuant to the earlier president of this honorable committee.
Thank you for that. Just to give the opportunity for the endorsers, to the movant and or endorsers to give their rejoinder to the objections. We now recognize Congressman Tolentino.
Mr. Chairman, good morning, and to all members of the Justice Committee, and all the ex officio members here, and of course to our majority floor leader. I will just give two manifestations, Mr. Chairman, on this. The first manifestation, Mr. Chair, is that my endorsement on this complaint to the impeachment of Chairman Bautista has nothing to do with the election protest of my brother. With or without the election protest, after hearing the allegation and reading the complaints, it is my moral obligation to endorse the complaint because of the national position of Chairman Bautista. For me, sayang po if we will deprive the electorate, the people, to know the truth. And we are also depriving Chairman Bautista to defend himself and clear himself. My second manifestation, Mr. Chair, is that, of course, I will submit, this representation submits to the final ruling of the committee, especially of the majority. Whatever will be the outcome, Mr. Chair, I will still seek and pray for a divine intervention that Chairman Bautista will resign, not only to save the institution, the Comelec itself, but also to save his family in these proceedings. Having said that, I submit, Mr. Chair, to whatever ruling of the committee.
Any other rejoinder from the movant and or endorsers?
Good morning to my very illustrious colleagues, and good morning, Philippines. Because I believe we are now being watched by millions upon millions of Filipinos who are very interested about this impeachment complaint filed against the chairman of the Comelec. The Comelec which handles the very electoral exercise that strikes at the heart of our democracy. There are serious allegations that are contained in this impeachment complaint. We have been arguing on the point of verification, on whether or not a verification of that complaint may be substituted. I do beseech, in spite of the learned and experienced opinions of my distinguished colleagues, that this is what, first and foremost, we must consider. It is our democracy that is being questioned here, and whether or not results of recent electoral exercises have in fact truly reflected the will of the people. Be that as it may I just put in also my 2 cents worth as regards the question of whether a verification of a complaint may be substituted. true, and I agree, that we must be very, very strict in accordance with the rules of the House of Representatives. And I must tell you, I have read the rules from page 95 until page 115 about 6 times, just to be sure that I would not miss anything so contained in our Bible. And in all of those 6 times, I have not seen a single prohibition when it comes to substitution of the verification. Nothing. None in any of the rules of procedure in impeachment proceedings from Section 1 until Section 20, from applicability of rules until effectivity. I do see, however, Section 19, which states, rules of procedure and evidence. The rules of court shall be supplementary to these rules, as has been correctly pointed out by my distinguished colleague, Deputy Speaker Castro. And so when we speak of supplementary, perhaps when this should mean that when there is nothing said in the rules, then we refer to the rules of court. And contained in the rules of criminal procedure, Rule 110, prosecution of offenses, Section 14. And this, in effect, might be my answer to the very, very distinguished gentleman from Albay, a good friend of my father, Pablo Garcia, who in times past had been in spirited discussions with Congressman Lagman. Section 14 states, amendment or substitution. It was earlier pointed out that there was no leave of court when such amendments or substitutions are in fact filed. However, if I may read Section 14 verbatim, Section 14, amendment or substitution. Excuse me? You have something to say? Okay, I thought that you wanted to add something, Congressman Waminal. Section 14, amendment or substitution. A complaint or information may be amended in form or in substance without leave of court, and when it can be done without causing prejudice to the rights of the accused. And so, for all of these reasons, taking into consideration what we have been constantly referring to as our rules in the House of Representatives, taking into consideration further what is contained in Section 19, as regards rules of procedure and evidence, where the rules of court shall be supplementary to these rules. For all of these reasons, I submit that the substitute verification must be accepted by this committee. Thank you, Mr. Chair.
Okay, I saw the hand of Congressman Roque.
Maikli
please,
lang po.
Very short, please.
Maikli lang po, Mr. Chairman. Malinaw na malinaw po na ang basehan ng pagtututol ng ating mga kasama at ating mga kaibigan ay dahil nagkaroon na ng desisyon ang kumiting ito doon sa kaso po ni Congressman Alejandro sa kanyang impeachment labang kay Presidente Duterte na henceforth hindi natatanggapin. Bagamat nung okasyon na yon, tinanggap po ng komite. Ano pong ibig sabihin yan? Ibig sabihin po na malinaw na nasa desisyon po ng mga miyembro ng committee ito kung po pwede pa rin matanggap ang ganitong verification o hindi. Wala pong nakasulat sa ating rules ngayon na nagsasabing hindi po pwede. Desisyon po ng committee ito na sa tingin ko pwede pa rin mabago. Bakit? Kasi ito po yung committee pa rin na magbibigay ng desisyon kung dapat nga baguhin yung kanilang huling paratang na hindi na i-allow ang ganyang mga verification. Ako ba ho ay happy nung nakita ko yung complaint? Well, sa totoo po, nais ko sanang gumawa ng bagong complaint, no? Dahil matagal naman akong nagsusulat ng mga ganyang complaint. Pero sa tingin ko po, nung panahon na yon, napaka-urgent po na malaman ng taong bayan yung katotohanan na nung minsan meron na tayong tinanggal na Chief Justice dahil kasinungalingan sa salin, bakit ang isang Comelec Commissioner hindi natin tanggalin dahil sa ganung basehan din? At pangalawa, at mas importante, yung pagtanggap na inamin ng chairman mismo sa television para makita ng buong bayan na kumuha siya ng referral fees galing doon sa biggest contractor ng Comelec na Smartmatic. Sa akin po talaga nakakaabala yan dahil sa aking paningin, hindi na po ito disputed, inamin naman niya. Bagamat sabi niya later on, wala namang masama dyan dahil ito naman daw ay walang kaso sa Comelec. Ang punto, hindi naman sinasabi na kailangan may kaso. Kinakailangan may interest lamang. So umaapila po ako. Tama po, ang komite magde-decide. Pero sa decision niya po, napakalaki po ng discretion dahil minsan ginawa na natin, pinayagan natin yung verification na sabi natin ay mali. So, dahil ganyan po ang decision, pwede pong mabago yan. At yan po ang aking apila. Dahil po sa mga paratang, nais ko pong malaman ng katotohanan, dahil demokrasya po ang nakasalalay. Maraming salamat po.
Thank you, Congressman Roque. So, narinig niyo po yung dalawang panig dito sa usaping ito. Klaruhin ko lang po, ang usapin po is all about the motion of Congressman Roque, seconded by Congresswoman Garcia, na i-admit itong substitute verification. Yun lang po ang pagbobotohan natin. At sabi ko nga, narinig niyo yung both sides. Again, let me admonish everyone that the decision in this particular incident will be based on your sound discretion, judgment, assessment of yung merits and or demerits of, tama po yun, re-echo ko po yung sinabi ni Harry, nasa sa atin po, pero nasa sa atin, individually, tayo po ang boboto niyan, at yun na nga po, because we practice democracy, then we will abide by the majority decision, and we are not bound by yung sinasabing rules of court, no.
Mr. Point of order lang, ano? Para maliwanag lang, how did this motion come to this committee? Because it is before the House of Representatives. So paano pa napunta ito dito? Hindi dumaan sa committee ang rules ito, ah. It was not included in the order of business because it is addressed to the committee. So paano, I ask the Secretary, paano ba napunta ito?
Comsec, will you please clarify this matter?
Thank you, Your Honor. On September 13, Your Honor, Attorney Manuelito Luna and former Representative Paras were presented before the committee the motion to admit substitute verification together with the substitute verification signed by the complainants Paras and Tapatio. It was received by the committee on September 13, Your Honor.
So, it was filed directly majority.
But this is for the House of Representatives. So can we dispose of this motion when it is not addressed to us?
There was an oral motion made.
That was my manifestation that that motion was improperly filed because it is not addressed to the committee, but it was addressed to the House of Representatives. That was my manifestation, Mr. Chair, when I objected.
That's why I cited the point of order, because if we have to treat this, then we should have admit this first as deemed filed before the committee. Para proper po yung ating procedure, because this is pleading. It's not addressed to the committee. It's addressed to plenary. yet we are voting on it. So, baka walang katuturan yung boto natin. So, if we want to treat this, then somebody has to move that we consider this as deemed filed before the committee.
Mr. Chair,
Congressman Doy.
I think with various exchange of the pros and cons, more or less the committee has more or less waived its jurisdiction towards considering whether the motion filed before this committee is proper or not. But then at the end of the day, it will still be the vote of this committee, members of this committee, whether to accept it or not. Because we have actually very much and lengthily debated on this one. After all, the motion is to accept or to admit or not. If we will admit it, so be it. If we will deny it, that will be definitely considered a scrap of paper. So I think we should proceed, of course, with due deference to our distinguished majority leader. The issue at hand now is, after all, motion to admit it. Pero I would like to, of course, abide with the sentiment and comment of the majority leader, considering that, really, how did that pleading came before this committee without passing through the endorsement of the committee on rules? And second, the heading actually is very much flawed because it addressed to the plenary, where in fact the jurisdiction is already before the Committee on Justice. At any rate, well, of course, with the consent of the majority, it is my position, Mr. Chair, that we might as well decide on the admission of the motion of Congressman Roque.
Thank you,
Mr. Chair.
Thank you for those clarifications. No, there is a point of order, and the chair wishes now to rule on the matter. So there is a pleading here, motion to admit
Mr.
substitute
Chairman,
verification.
before the ruling, can I say something?
In relation to this.
Yes,
Thank
Mr.
you.
Chairman.
Okay, you have 1 minute, Your Honor.
There is a pending motion of the distinguished Congressman Roque, which this committee has to dispose of. Number two, with more reason, since legally this supplemental or amended verification is not with the committee, with more reason, we should deny the motion.
Thank you for those. In fact, that was what I was going to rule on.
Mr. Chairman,
Mr.
Mr. Chairman, one last comment. Much has
Okay.
been made, Mr. Chairman, of the vote of the committee. But as the majority leader points out, what is voted upon in the committee must still pass the vote of plenary. And that is what really empowers the votes of the committee. We sit here by election by plenary. So the decision of the committee in the Alejandro case that liberality would no longer be exercised was upheld by plenary voting upon the committee report. So any decision we make here must pass plenary, and it's imprimatur. That is the main import, Mr. Chair.
Thank you, Deputy Majority Leader. In
Mr.
fact,
Chair.
may I just make a ruling on this because this will I'll probably cover any and all of your manifestations. As I said, and I'd like to thank Congressman Lagman for stating that there was a motion made orally by the movant, Congressman Roque, duly seconded. And there was an objection, and that is what we are ruling on. Just for clarity, you know. Now, the other point is that, as pointed out, even in this motion, there is a defect, and I guess it is revealing that this motion should have been actually addressed to the House of Representatives. And so jurisdiction of the committee really comes or emanates from what is referred to us by the Rules Committee. Of course, we have already acquired jurisdiction over the main case, over this impeachment proceeding after this has been referred to us, and any and all matters that are not covered by that referral is something that is beyond us and may be considered ultra vires. At any rate, the point of the chair is that yes, for the longest time, the rules on impeachment are not that detailed because there is not much impeachment cases really that went to the Committee on Justice, and so this may be the reason for the dearth of specific rules on the matter. But then this is why we're clarifying this, and this is why in the first impeachment complaint tackled by this committee, we tried to be very clear. In fact, this chair had even ventured to go on a impeachment 101, trying to educate everyone about what impeachment is and what are the requirements therefore. Of course, I cannot be exhaustive, I cannot be as comprehensive because there are matters that ought to be discussed in this committee. But at the end of the day, whatever decision will be upon the individual assessment, judgment, discretion of each member. And there being a motion duly seconded and equally objected to, a lengthy debate, pros and cons on the matter, with even a rejoinder on the objections of the many members. I think this committee is ready to rule on the matter of admitting the substitute verification. So there being a motion duly seconded, objected to, the next action of this committee is to divide the House. All those in favor of a substitute verification.
Before we divide the House, will you please restate for clarity the position?
So all those in favor of the motion is to submit admit the substitute verification to substitute for the defective verification appended to the impeachment complaint filed and referred to this committee on September 7, 2017.
Mr. Chairman,
So those,
may we object to the proposition because there's not been any admission that the original verification is in fact defective. My appreciation is the substitute is only...
Point of order.
yes, Majority.
We are already voting. We cannot interrupt. Please proceed.
Yes, yes.
You make your manifestation later, but you cannot object to the... you cannot interrupt the process of voting.
Okay, so those who are in favor of the motion of Congressman Roque to admit the substitute verification in lieu of the verification earlier appended to the complaint filed on August 23 and referred to this committee on September 7, please stand up. So, thank you. So all those who are not in favor of the motion, please stand up. May. I think the decision is pretty obvious, but for the record, There are 3 in favor of the motion. Sorry. Sino? Hindi ka member. Member, hindi ka member. There being 2 members in favor of the motion and 27 members against it, the motion to admit is denied.
Mr. Chair, nadagdag bawas pa. I understand, Mr. Chair.
Mr. Chair.
Nadagdag bawas pa. Only 2.
Mr. Chair, Mr. Chair, having disposed of the motion of the Honorable Roque not to admit the substitute complaint, this humble representation therefore moves to declare the Paras and Tapatio complaint against Comelec Chairman Andy Bautista insufficient in form.
Objection, Your Honor.
Objection.
Any second to the
Second.
motion?
I second, Your Honor. Ikaw naman second.
There being a motion duly seconded and
So, secondahan mo yung...
Opposed, and there was...
Mr. Chair,
sige, I second, she opposed.
Mr. Chair,
andali mo na.
Mr. Chair.
Ano ba yung... We will just clarify. There is a motion
may I,
to declare the complaint insufficient in form.
Mr.
There
Chair,
was a
may
second. Sinong nag-second? Congressman Salo seconded.
Chair.
This was opposed by Congressman Roque and Congressman Garcia. So we now
Mr. Chair.
entertain.
Under the guidance of my majority leader, being a stickler for the rules, may I just make the manifestation that motions must be in the positive. So, could we please rephrase it? It must be a motion to find it sufficient, not insufficient. And then people may object.
Okay.
May I just manifest?
So,
Mr. Chair.
Mr. Chair, with the enlightenment of the Senior Deputy Majority Leader on the procedures insofar as motion is concerned, I am therefore withdrawing my motion declaring the complaint insufficient in form.
And we now recognize the endorser and or movant, Congresswoman Gwen.
With due indulgence of Congressman Uaminal, who I am sure would have wanted to make this positive motion, I now move that the impeachment complaint filed before this committee against Chairman Andres Bautista be declared sufficient in form.
I second, Mr. Chair.
I object.
Objection.
Mr. Chair.
Okay, there is a motion duly seconded. I see a lot of objections coming from the members. May the chair just please see the hand of those who are objecting so that we can properly record this. So, nauna si Kong Edsel and then yung mga hindi pa doon muna tayo sa dulo. Ha? Okay. So doon muna. Yung iba naman, let's give time for others. Sinong while we are listing the objectors, we now recognize Congressman Edsel Lagman.
Thank you, Mr. Chairman. The verification in the Jimenez Malyari impeachment complaint against the Chief Justice. No. yes, against the Chief Justice. And the paras to Tapatio complaint against Comelec Chairman Bautista are identical. Let me quote. In the Jimenez Malyari complaint, the pertinent portion of the verifications reads, and I quote, "The allegations therein are true of our own knowledge and belief on the basis of our reading and appreciation of documents and other records pertinent thereto," unquote. In the Paras Tapatio complaint, the pertinent portion of the allegation reads, "The allegations thereof are true of our own knowledge and belief, and on the basis of our reading and appreciation of documents and other records pertinent thereto." They are the same, except that there is the word therein in the Jimenez Malyari complaint, and the word in the Paras Tapatio complaint is therefore. All other statements on the verifications are the same. Mr. Chairman, since the Jimenez Malyari complaint was found to be insufficient in form, then the same ruling must be applied to the Paras Tapatio complaint. Thank you, Mr. Speaker.
Thank you. We now recognize Congressman Roger Mercado for his objection.
Thank you very much, Mr. Chairman. I've been wanting to be heard also because we're just...
That is why you're now recognized.
I believe, Mr. Chairman, members of our committee, that the decision to render this complaint as insufficient in form is well studied, and indeed, this should be supported. We object because that is the rule. We have to follow. That it should pass the requirements of verification. Secondly, that we have been discussing this, and we are now ready to make our decision. Deputy Speaker Gwen Garcia is a good friend of Southern Leyte. But sad to say, even the rules of court that she based her argument states that it can only be amended if it will not prejudice the complainant or the defendant. Under this case, the filing of the complaint will prejudice, of course, the defendant. He will go through so much sufferings through the hearings. Therefore, it will definitely prejudice the defendant. That's why this motion that it is insufficient in form should be supported. Thank you very much, Mr. Chairman.
We now recognize Kong Doy Liachon.
Mr. Chair, I do not want to elaborate the issue further, but it's quite very clear that with the non-admission of the amended verification, there's no point of discussing more because there was tacit, explicit, implied, and expressed admission that the verification was defective in view of the filing of the motion to amend the previous verification. And that motion being denied, meaning the old verification, which is defective, is now the subject of the instant motion. Being defective in nature, I think there's no point of belaboring that issue. And for that reason, again, in view of the motion, I object to the motion that the impeachment complaint be declared insufficient in form for obvious reason that it should be, there's no leg to stand on considering that the motion to admit it was already previously denied. Thank you, Mr. Chair.
Mr. Chairman, may I just make an important manifestation?
Thank you,
May I
Majority.
please advise, kasi nakukunan tayo ng camera, the complainant don't approach the chair. Lalo nagbubulungan kayo, it might give some picture of impropriety. Maski, we're all lawyers. When a party wishes to address, then he should seek permission to approach the chair. But in fact, I also called his attention when he came to my office the other day. Was it the other day? Because Jing was my colleague in the 11th, but I said, I cannot talk to you because you're a complainant in an impeachment case. Magkakaroon ng impropriety. Pagkakuan. Pinatawag niyo ba? Ayun, sorry. Pinatawag pala ni chair mismo. Thank you. Okay, but kasi po, yung media is sometimes you don't understand. But nagbubulungan yung chair at saka yung complainant, yung respondent, wala naman dito. So, yun lang. So, si chair pala ng patawag, I submit to the chair.
Thank you, Majority. Anyway, just for clarity, I was approached earlier and he wanted to make a manifestation for him to be recognized. But of course, we are bound by rules and we are not yet on the matter of the substance or even probable cause. So this is really only among the members of the House of Representatives, the endorsers, and so this is not yet his time to be recognized, and that is the reason why I conveyed to him that this is not allowed under our rules. So that is the only thing that was discussed. No?
Thank you. Thank you, Mr. Chair.
Thank you, Majority. We now recognize Congressman Waminal.
Thank you, Mr. Chair. Consistent with my stand in the case of Jimenez versus Chief Justice Serino, where I objected in the motion as to the sufficiency in form, which led to the decision of this committee declaring the complaint insufficient in form, strongly adhering to our ruling in the case of Alejandro, setting aside now that should be the last time that we should consider liberality in the issue on impeachment complaint, especially on the issue as to sufficiency in form. And with that, after the committee denied the motion to admit the substitute verification, then this humble representation maintains his position and object to the motion declaring the complaint sufficient in form.
Thank you, Congressman Vice Chair Ominal. We now recognize Kong Salo and thereafter Congressman Crisologo.
Thank you very much, Mr. Chair. Consistent with the manifestation that has already been made by this representation a while ago, and consistent with the arguments that I propounded therein, I respectfully submit that in as much as the verification of this particular complaint is defective in form, then we have no choice but to declare it as such defective. Thank you very much, Mr. Chair.
Thank you, Kong Salo. You now have the floor, Congressman Crisologo.
Thank you very much, Mr. Chairman. just very short, just an admittance. The mere fact that they filed a substitute verification is an admittance that the original verification is insufficient in form. And so with that, I object, Mr. Chairman.
Thank you, Congressman Crisologo. You may
Yes,
wish
thank
to
you, Mr.
issue
Chair.
a rejoinder before
Well,
we
ganun din po ang aking sasabihin. Importante po na malaman ng katotohanan. Ang verification po sang-ayon sa Supreme Court ay sapat naman, and I will quote the case, no? Ang certification ay sapat if sinasabi naman ng mga nagrereklamo na ang kanilang mga paratang sa kanilang pagkakalam ay totoo at hindi lang sila nag-iimbento. So kinakailangan po ang ating paluntutunan ay naniniwala ba sila na tama sinasabi nila at hindi sila gumagawa-gawa lamang ng mga sabi-sabi. Ako po'y nag-endorso nga nitong complaint nito dahil asawa mismo ni Chairman Bautista nagsabi meron siyang mga tagong yaman at meron siyang tinatanggap na mga halaga galing doon sa pinakamalaking contractor ng Smartmatic. Kaya sa akin po, tingin ko naman, pag pinag-uusapan ay personal knowledge, siguro may personal knowledge naman si Mrs. Patricia Bautista dahil nakita niya yung mga certificate of bank deposit, yung mga bank book, nakita niya yung mga statement of account, at ito sana ay mga original pa, hindi lang authenticated. At kung tayo pagbibigyan natin ito, hindi lang po siya magsasabit ng mga certified true copy. Kung ano yung nakita niya sa kanyang sariling pamamahay, ang kanyang isusumite para dito sa committee ito, mas malakas pa pong epekto niyan kesa dun sa mga authentic documents lang dahil original ang kanyang hawak. So dahil dito po, bagamat alam kong wala kaming numero, umaapila ako sa aking mga kasama, hayaan po natin malaman kung anong katotohanan, hindi lang po ng committee ito, kung hindi ng sambayan ng Pilipino. Maraming salamat po.
Maraming salamat. I see Congressman Lagman who wishes to issue a surrejoinder.
Thank you, Mr. Chairman. There are various fora as avenues to know the truth other than an impeachment proceeding. Number two, with respect to the suppletory effect of the rules of court, there is nothing in our rules with respect to amendment of the complaint of verification. Absent such rule, there is nothing to supplement. Thank you, Mr. Chairman.
Thank you for that.
Mr. Chairman,
final...
if the independents were allowed to make a surrejoinder, may I be allowed also? Well, like I stated in the Alejandro case, our colleague, Representative Alejandro, was alleging that Matubato knew of several EJ case. Dapat si Matubato ang complainant so that his verification will stand water. Dito rin po, dapat si Mrs. Bautista ang complainant at in-endorse niyo po sana. Hindi po Ang nag-complain po si former Congressman Paras at saka si Ferdy Tapatio who do not have any personal knowledge. So, paano naman po yon? Nagtataka naman po ako kung bakit hindi ganon. In fact, wag ko naman pa, but last na lang po ito. Sumulat pa ho kayo sa NBI, hindi po ba? Asking, it forms part of the record. You wrote to the NBI asking Director Giran that you be furnished a copy of the complaint affidavit of Mrs. Bautista. At linagay po ninyo doon because this is required. Ito po. You wrote Attorney Giran on August 14 asking that you be given copies of the documents. And then you stated our said client is resorting to this request owing to the fact that the Committee on Justice of the House of Representatives will not accept any documents other than the certified or original appended to the impeachment complaint. Yet, inattach po niyo yung affidavit ni Mrs. Bautista dito, hindi rin po certified true copy. No, wala po kayong speaking rights dito. We are talking. So, we now move that we divide the House.
Sir Bata lang.
Mr. Chair.
So, alam nyo, sa kanya lang, hindi naman applicable. Suppletory nga, pero anyway, yung pinakadulo doon, yung surrejoinder, wala nang kasunod yun eh. Hindi ko alam kung ano pa susunod doon. Ano ba ang tawag doon? Division of the House. Dapat division of the House na. Anyway,
One last.
rejoinder to. Sige po, just to accommodate Congresswoman Gwen.
Mr. Chair, we are on the subject of whether the complaint is sufficient in form. All of the statements of those that find this complaint insufficient in form, whether it be the substitution or the original verification, refer to the Alejandro versus Duterte case, where in fact, and I have here the transcript, the full transcript of what transpired on that day, the 15th of May 2017, where we lengthily discussed the Alejandro impeachment complaint. It has been said and repeated again and again that we had in fact already decided that henceforth any impeachment complaint that shall be found insufficient in form shall forthwith be dismissed. And that liberality will only be exercised that single time in the case of the Alejandro complaint. And I shall read from the words of the majority leader himself. Our first task is to determine sufficiency in form, and looking at the complaint, there is a verification. In the case of Alejandro, he did not use the form that was adopted by the Dante Jimenez, Attorney Malyari, and this time also the two complainants that we have here in the verification complaint. But it was stated that there will no longer be any, it was stated that there would forthwith be a warning on all future complaints, that it would no longer be entertained. Now, on the basis of all of these, after lengthy deliberation, when we found the Alejandro complaint as sufficient in form, a committee report number 257 was presented to plenary. In this committee report, and I shall read, this committee report, signed by the chairman of the Committee on Justice, submitted on the 22nd of May 2017, entitled regarding House Resolution 1015, entitled Resolution Dismissing the Verified Complaint for Impeachment and the Supplemental Complaint Affidavit filed by Representative Gary Alejandro against President Rodrigo Roa Duterte. In the final paragraph of the committee report, it states, finally, the Committee on Justice recommends that the rules of procedure in impeachment proceedings of the House of Representatives be amended to explicitly allow the dismissal of impeachment complaints based on insufficiency in form. This was the recommendation of the committee. The attached resolution, House Resolution 1015, signed by members of the House Committee on Justice, states that, amongst the whereases, Whereas in its hearing held on May 15, 2017, on a motion to declare the verified complaint and supplemental complaint sufficient in form, the committee declared said complaints to be sufficient in form, albeit defective, by a vote of 41 in favor, 1 against. Now it goes on to talk about insufficiency in substance. There is nothing here in this resolution that moves to declare a complaint found insufficient in form to be outright dismissed. Yes, we discussed this lengthily. There is the existing colatilia. But I submit, Mr. Chair, insofar as Committee Report number 257 is concerned, the recommendation of the Committee on Justice that the rules of procedure in impeachment proceedings of the House of Representatives be amended to explicitly allow the dismissal of impeachment complaints based on insufficiency in form, though approved by the House, continues to be a recommendation unless and until there was a subsequent motion to amend the rules of the House. There being none, not even in our own House Resolution 1015, where we did submit that the complaint, though defective, was found to be sufficient in form. And in no other whereas, nor in any other paragraph, is it mentioned that thereby, henceforth, all other complaints found to be insufficient in form should therefore be dismissed. I submit, Mr. Chair, absent such a formal amendment to our existing rules of the House of Representatives, the existing Rule on Committee Proceedings, Section 4, Determination of Sufficiency in Form and Substance, holds. And what is this? Upon due referral, the Committee on Justice shall determine whether the complaint is sufficient in form and substance. If the committee finds that the complaint is insufficient in form, it shall return the same to the Secretary General within 3 session days with a written explanation of the insufficiency. The Secretary General shall return the same to the complainant or complainants together with the committee's written explanation within 3 session days from receipt of the committee resolution finding the complaint insufficient in form. Should the committee find the complaint sufficient in form, it shall then determine if the complaint is sufficient in substance. The requirement of substance is met when there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. Now, this is important. If the committee finds that the complaint is not sufficient in substance, it shall dismiss the complaint and shall submit its report as provided hereunder. Therefore, Mr. Chair, based on the Alejandro precedents and based on what has in fact been presented by virtue of a committee report, by virtue of the House resolution that we had, that was passed by plenary, there is no such mention that if a complaint is found to be insufficient in form, then it should outright be dismissed.
Yeah.
Thank you, Mr. Chair.
Thank you,
Mr. Chair.
Congresswoman
Chair.
Gwen.
Mr. Chair, may I be allowed to
Just
Mr.
for
Chairman.
clarification, in the second impeachment complaint of against CJ Sereno, I distinctly recall that we dismissed with prejudice the second impeachment complaint. So we have already, in fact, effected the intent of the committee as approved, and which was approved in plenary in the second impeachment complaint against Chief Justice Reno. So just to correct that we have not executed or implemented the rule. Now we would like to recognize Congressman Rimpi Bondok, who is in charge of the rewriting of the rules for some clarification on the matter.
So, thank you, Mr. Chairman, and for the information of our colleagues. First, let me thank you for giving me the responsibility. I am now the chairman of our Rules Rewriting Committee, a position previously held by my much respected boss, the Majority Leader. So, the recommendation of the Committee on Justice regarding insufficiency in form leading to dismissal is well taken by the Rules Rewriting Committee. We have had 3 meetings already discussing in depth changes to the rules of the House and to the rules of impeachment. But we have deemed it in the interest of fairness and justice and for the information of the public that we will not change the rules in the middle of the game. While all of these impeachments have been filed, what is sauce for the goose is sauce for the gander. Meaning, we should not confuse the public and the members by changing the rules in the middle of impeachments ongoing. We believe that the rules themselves and the precedents set by the committee in its actions, as explained by the chairman, are guidance enough for the voting of the members. And given a chance when there is no impeachment, then we will submit our suggestions which will be voted upon by plenary. But we will note the suggestions of the various committees and we will incorporate them at the proper time, so as to make sure we do not disrupt the proceedings or give a hint of impropriety on why Rule A was used for the Alejandro impeachment, changed, and now Rule B is being used for impeachments filed by subsequent impeachment endorsers. So for clarity, these rules are being considered, but our precedents are very clear and we leave it to the wise judgment of members, the interpretation of the actions of the committee as enunciated very well by its chair. Thank you.
Mr. Chair.
Shall we now proceed with the voting?
If you can allow a little time, Mr. Chair. Maybe
Sige.
2 minutes.
Okay,
3 minutes.
pwedeng 1 minute lang.
Subukan ko po.
Sige po.
Thank you, Mr. Chair. Even if we accept or we have granted the substituted verification, Mr. Chair, we will still arrive at the same conclusion. The form is still defective. Why? In paragraph 3 of the substituted verification, it says that we have read it and the allegations therein are true and correct of our own knowledge or based on authenticated records. It is not true, Mr. Chair. Number 1, paragraph 15, page 11, is based on the website. It is not authenticated. Paragraph 16, 17, 18, 19, and 20, all on page 12, are sought from Philippine Star. They were never authenticated. There is a procedure in authenticating this. They never did. What is the materiality?
We're not into that yet.
Ito po. Under, on paragraph 40, Bautista by his own admission had received referred fees. Wala po yung authenticated records. Last na po. Last lang. What is the relevance of the quotation from Sir Walter Raleigh? Ito po yung conclusion. In conclusion, complainants would like to quote from Sir Walter Raleigh. This is a British novelist. Hindi ko po maintindihan kung bakit. It is defective in form, Mr. Chair.
Thank you,
Salamat
Congressman
po.
Marcoleta. So we now, well, the parliamentary status is that there is a motion to declare the complaint sufficient in form. It was duly seconded. There were many objections there too, so there being extensive discussion on the matter, we now divide the House. So all those who are in favor of the motion to declare the complaint sufficient in form, please rise. Two. So all those the voting. All those who are, thank you. All those who are against the motion, please rise. While counting, I guess the outcome is pretty obvious. Just for the record, but I guess the for the record, there are none. Those members only, members only. Okay. Oh, ilan na? So, there being 2 members voting in favor and 26 against, the motion is defeated.
Mr. Chair.
Then what is now?
Mr. Chair. Motion, Mr. Chair. I have a motion, Mr. Chair.
Before that, we will dispose of this again, similar to the disposition in the complaint of Jimenez versus Chief Justice Sereno. The result of the voting on the insufficiency in substance of this complaint
In form.
in form of this complaint renders this complaint dismissed.
Motion. Mr. Chair, by the very admittance of the Deputy Majority Leader, the Honorable Juan Pablo Bondok, now the Chairman of the Committee on Rules, making a manifestation on the points that I had presented as regards what rules should prevail. And with his admittance that, in fact, he would not wish to amend the rules in the middle of a game so as not to cause confusion. Therefore, in other words, Mr. Chair, this representation is faced with no other conclusion that, in fact, what is really prevailing upon all of us right now, Alejandro Doctrine notwithstanding, is the present House rules on committee proceedings on the determination of sufficiency in form and substance. And that, so therefore, Mr. Chair, I move that the impeachment complaint against Comelec Chair Andres Bautista, having been found to be insufficient in form, be now returned to the Secretary General within 3 session days
Point of
with
order,
a written
Mr.
explanation of the insufficiency.
Point of order.
I
Before
am
the
still.
motion. Point of order.
Please let me finish my motion so that everything will be in order. It shall be returned to the Secretary General within 3 session days with a written explanation of the insufficiency, and the Secretary General shall return the same to the complainants together with the committee's written explanation within 3 session days from receipt of the committee resolution finding the complaint insufficient in form. I so move, Mr. Chair.
I second, Mr. Chair.
what is the pleasure of...
Mr. Chair, I'm raising
I
this
object,
point.
Mr. Chairman.
I'm
what is
raising
the point
this-
of order?
I'm raising this point of order because the Honorable Congressman Garcia is using the wrong procedures. Why I am saying that this is she is using the wrong procedure. While she might be correct in stating and pronouncing the language and explicit provision of the rules of procedure, but the correct interpretation here is that it is the express provision of the rules versus jurisprudence. What is the express provision of the rules? That is the rule that she is reading now, the rule on impeachment proceeding. What would be the exception to that rule? The exception to the rule is the jurisprudence. And what would be the jurisprudence here? The Alejandro case. Therefore, if we interpret that law, we will not read that law as to the letter of that provision. We will reconsider and harmonize it what we call jurisprudence or the exception to that rule. What would be now the exception? The Alejandro case. That is how we interpret the rules. If we liken this with the Supreme Court ruling, there is the express provision of the general law, Republic Act, or whatever law. If we have a case, particular case, and that jurisprudence would be an exception, that would be a tantamount to an amendment to the express provision of the law. So if we have to interpret now what would be the correct procedure of our impeachment proceeding, express provision of the law, that is the impeachment rules, plus jurisprudence. Jurisprudence is the Alejandro case.
Thank you. Thank
Mr.
you
Chairman.
for those clarifications. In fact, that is what really was stated clearly by the Deputy Majority Leader, that these are all already in process, except that the Rules Committee, which is rewriting the rules, are constrained to do it, but effectively we have already executed and took cognizance of this particular rule that was approved by plenary. So, operative na ito, as in fact, we already applied it in the case of Jimenez versus Sereno. Anyway, but just to answer your point, I will clarify so that we will not have to go through. In fact, today is the third session day of the dismissal of the Jimenez complaint, and I am just about ready to transmit this to the Secretary General. So don't worry, I am also a stickler for the rules, strict application of the rules, and we will comply with the requirements of submitting our recommendation and or report to the Secretary General. So we will comply, so don't you worry about that.
Mr. Chair, just to really clarify your statements, then in other words, the same fate will happen to the Bautista impeachment complaint, that within 3 session days this will be submitted to the return to the Secretary General, and then the Secretary General shall return such complaint to the complainant with notice of having it been declared insufficient in form without necessarily dismissing that complaint.
We have already applied the rule, and it is dismissal with prejudice on the Sereno complaint. So we will follow that doctrine. This is the principle of stare decisis that we will apply in this particular case. Anyway, pareho lang po ang epekto niyan. You can also cite the rule that it does not say that you can correct it. Please cite me the rule that it can be corrected and it can be refiled.
the rule that states, as I said,
It can be returned, and once it is returned, it is period, finished. Because of the one-year bar rule. And so there is nothing in the rule that says that you can correct it and you can bring it back and you can modify whatever within the without violating the one-year bar rule. So anyway,
there is nothing in the rule as well, Mr. Chair, which states that it should be dismissed.
anyway, the court, the committee has already ruled on the matter. We do not want to deviate from our previous ruling on the impeachment complaint of Jimenez versus Sereno, and therefore, as mentioned, as ruled upon, this complaint is dismissed for insufficiency of form with prejudice.
Mr. Chair.
No, there's a motion,
Wala na
Mr.
eh.
Chair.
Na-dismiss na eh.
You already, there was a standing motion.
Yeah, we have already a ruling on that.
Manifest.
We will comply. We will comply. We have already. I have the chair has already responded, and we will not violate that. That we will refer it. We will bring it back to the level of the SecGen with the corresponding report and recommendation.
Well, station, Mr. Chair, I think it's apparent that there is a discrepancy between our written rules and the practice of the committee. And my only manifestation is, although it is the House that has the power to promulgate rules, we must also enforce the rules as provided currently, and as approved by the plenary. And I believe that if we were to give priority to practice over the written provisions of our rules, we are, or we might be violating, in fact, our own rules. So until the
Point of
rules
order,
are
Mr.
in fact
Chairman.
amended, it's just a manifestation. People could disagree, but that is the humble manifestation.
Mr. Chairman, I must set that in order. The implication of the statements of the Honorable Roque are that we are following our own rules without imprimatur of plenary. May I remind the gentleman that the committee report regarding the Alejandro case, where the decision was insufficiency in form, leads to a dismissal of the complaint, was submitted and was approved by plenary, which is why we follow that in the Jimenez case. Thank you, Mr. Chair.
So, thank you for that. And since the matter has been disposed of, any motion to the favorite motion?
Mr. Chairman.
Huaminal?
I move to adjourn, Mr. Chairman.
Okay. I second the motion.
Thank you, gentlemen. The hearing is adjourned.